violated the laws as they related to the rules of discovery. I think they played real
Why did the prosecution, I mean, why didn't the judge call them on it?
Good question. Good question. When we had a problem with discovery, early on we had a problem with discovery, and the judge precluded us from calling most of our domestic violence witnesses until the end of the trial. And when an FBI agent failed to turn over to the defense and to the prosecution evidence which indicated that O.J. Simpson owned a Bronco with extremely rare Bronco fibers. I guess there was something like 250 Broncos in the United States having the same type of carpet as O.J. Simpson's Bronco. Judge Ito excluded that evidence. The jury never heard it. But in the case of the defense, when they had discovery violations, you know, it was a slap on the wrist, and they proceeded on with their case. And we suffered.
Somebody stepped forward to say, look, what happened in this case was the defense outlawyered the prosecution. The prosecution had a burden to bear. It was a African-American superstar on trial. Secondly, it was tried in the venue that it was tried in. So it was a difficult case for the prosecution. But in the end, when push came to shove, when the rubber hit the ground, the defense outlawyered them. Could you accept that?
Well, no, I couldn't accept that. You know, as prosecutors, we don't have you know, we don't put on a big show, a big production. You know, no show tunes. When you're a prosecutor, you just put on the evidence. Sometimes it's a little dry. Sometimes it's a little flat. What we had on our side, and to our advantage, we believe, was the truth.
Well, you also had, in the judgment of Gil Garcetti, a mountain of evidence.
And I agree with that characterization. We had a mountain of evidence.
And with a mountain of evidence, in your judgment, it was overcome by playing a race card, things that you just said, and allegations of, and a couple of slip-ups with respect to compromised witnesses or police officers.
Well, I think there are other factors to consider. I think a potential bias on the part of some jurors, a predisposition to find them not guilty, regardless of the quality of the prosecution's case. And I think as well, I think we have to consider the impact sequestration may have had.
Television, sequestration, all of that.
Sure. You know, by the end of this trial, pretty much everyone involved in it had a financial interest in it. I mean, we know for a fact that
including you.
Not me. Not including me. Not including
well, but
me.
who did then? If everybody did, why are you accepted from that?
Well, I hadn't had contact with agents during the trial. I hadn't signed book contracts. I had nothing to do with those kinds of people.
Who had?
Well, I'm sure the defense had.
Are you sure?
Well, they talked about it.
But they signed contracts before the trial was over?
No, but they talked about what types of advances they might get and what types of, and which agencies they might go with in terms of representation on book contracts. I remember a conversation one day, it was in Chambers as I walked in, and there was some mention of, is it ICM?
Yeah, well, that's an agent. It's a big one.
Okay. And there was some mention, as I recall, it was Cochran and Shapiro. And Ito was present, and they started talking about going with ICM and $2 million advances and the like. And Ito said, hey, I don't want to hear this. I have nothing, you know, I don't want to have anything to do with anything like that. So stop talking about it. And I remember Cochran turned to me and says, Chris, you don't have to worry about that. Nobody's going to want you to write a book. Nobody cares what you have to say.
So do you feel a certain sense of vindication here?
No, I don't.
This book has been written and well received.
Well, I am pleased that it has been written and well received. I am pleased that people are reading it, more so than anything.
Let me talk a little bit about evidence. As I said to you, almost everybody followed this better than I did and more than I did, so my apologies of not knowing as much as I would like to know about the trial. We would occasionally focus on the trial and have people come in, some of those pundits, and talk about it. And I always found it interesting and fascinating. We didn't do as much as a lot of people did. Having said that, here's one thing that is intriguing to me. It's a little point. Did you have information that Detective Furman had acknowledged using epithets in traffic cases before he did his prep session and denied it.
Mark Furman indicated to me that he had used epithets in the past. Okay. And as I recall, I posed a question to him, and I'm not sure the exact language, but you know, have you ever used epithets? What are you going to say if they ask if you ever used epithets? Well, sure, I've used them. Never on the job, I think he said. You know, I might have used them in traffic cases or something like that, or words to that effect. Okay. And we had that conversation, and I was uneasy. And so it was a few weeks later that I assembled the so-called mock cross-examination. And we looked further into that issue, and I asked him, well, have you used that word in the past 10 years? And he said, no. Well, I thought to myself at the time, well, given what I knew of his past, what was the likelihood that that wasn't true? I had no evidence or information that it...
Other than what you'd heard from his own mouth.
I had no evidence or information that he used
Right.
that word in the past 10 years. None whatsoever. I had no evidence. I had no evidence other than what we all had, and that was Kathleen Bell and Kathleen Bell's girlfriend. And so when he said that, I thought, how would a guy like this know? Would he know? Who would count? Who would keep count? And if you asked me if I'd used an epithet in the past 10 years, if nothing else, I'd have to say, at the least, I don't know, or yes, I did, but I don't know which one and under what circumstances. But Mark Furman was adamant that he hadn't.
Adamant and demonstrative in saying no.
No.
And you had no reason from any conversation, I mean, 10 years seems to be a crucial point here. He said he used epithets, then he says in the last 10 years, no. That 10 years seems to be the key point, doesn't it?
Yes.
So he says that in the prep session, and he goes out there and he says it on the stand.
Yes.
You were asked to interrogate him. You chose not to.
That's true.
Because?
Well, call it instinct. Call it a sinking feeling.
That he was lying.
Deep down in my gut. Not necessarily that he was lying, but that I couldn't accept that answer. And I had searched far and wide through my investigators, the Internal Affairs Division of the LAPD had searched, the tabloids had searched, the media had searched. Everyone was out to get something on Mark Furman. No one could find anything. I wasn't willing to accept that answer. That was his answer, and that was his position. I couldn't disprove it, but I wasn't going to put him on. I wasn't going to put him on. I'd caught enough hell.
You weren't going to put him on, meaning you weren't going to be the one who interrogated him.
That's correct.
You were not going to. You had to go along with him taking the stand, and because the defense would have called him regardless, probably.
Absolutely, and I think we had to call him and place him on the stand if we were going to maintain the integrity of our evidence.
Do you now, well, obviously because of what he said on that tape, beyond that tape, do you have reason to believe he lied?
Beyond the McKinney tape?
Yes.
Well, of course, other people came in during the same time period, so...
You believe them, too?
Well, one of those people I don't believe necessarily, but I think that the evidence weighs in the greater, that the greater probability is that he lied, absolutely, in addition to the McKinney tape. I mean, there were other people who I mean, we would have to conclude were telling the truth about Furman as well.
And if you knew he was lying, you would have a responsibility. If somebody in the DA's office knew that he was lying, would they have a responsibility to go to the court and certainly to go to the prosecution and maybe go to the court and say, this witness can be impeached?
If someone on the prosecution team knew that he had used the N-word in the prior 10 years, they had a duty to tell Judge Ito.
To tell the judge, to tell the court.
Yes.
You know, that would be their responsibility. And no one even came close to doing that. I
don't believe anyone knew. I mean, I knew nothing of the McKinney tapes. I could not imagine such a set of circumstances.
Do you, Barashek and all those people, Barashek and Peter, if I were here on this program, soon after the trial was over, and talked to me at length, what do you think of them, first of all?